All right. Let's go.
Counsel, your reaction to the ruling of the court.
Out.
Came out of court. You all know what was scheduled for today was to be the pre-trial hearing. But before that, the petitioner's team, lawyers, had indicated that they had filed an application for a review of the court's ruling yesterday on the dismissal of this petition. I'm confident that in the short course of time, you'll be apprised with the issues that have been set down. The court has also given an elaborate timetable for the hearing. It is instructive to let you all know that the 3 issues that we set down as our memorandum of issues have been incorporated largely in the issues set down by the court. Now the court has also, second respondent's answer, that matter was raised by the second respondent's legal team as a matter which should be considered by the Supreme Court, and that has been set down for preliminary legal argument. Professor Ashi Kote, Justice of the Supreme Court, we all know as lawyers that the filing of an application for review does not operate as a stay of proceedings of the matter in court. Well, the return date for that application, I don't understand what that submission is supposed to mean. They always are the first to make those submissions, but that submission has no place in law. As petitioners, they should have known that an petition, and you don't know that you have to file a witness statement. You don't know that you have to settle a memorandum of issues. I don't understand what is meant by sacrificing justice on the altar of expedition. Justice delayed is justice denied. So what is it? They are just not ready. It should tell all of you of a bad farm on your tools of implementation. Your farm is your farm, and it depends on how you cultivate it. So we should also not pander to this repeated rhetoric of sacrificing justice for
It's not a stay on proceedings. However, as an interested party, are you not concerned that in the future, when this case has traveled and the issues are brought back, that it could take all of us back to the very beginning of matters?
The Supreme Court, so what happens today will determine the course of the proceedings. Final question? Any more? Thank you. Thank you. Yeah, according.
Yes, what is the evidence ask?
No, I think we just
okay. Case management is a discussion between the parties and the court as to how the trial is going to proceed. Today, that's not what happened. We were told what is going to happen. There was no discussion as to what our views were on how the meant. Now, you are all aware already that we had an application for interrogatories. We've served them with notice to admit facts. We've served them with notice to actually inspect documents. All those things have not been attended to. We have actually filed an application for review. We file witness statements by close of business on the 21st. For us, it's shocking. It really doesn't make sense to us as lawyers who've been practicing in the courts for so many years. And we know what the rules are. We know why to delay the case. They were grounded in law. The fact that the petitioner has interrogatories to serve on the respondents. Now, interrogatories, as is stated, are to aid the trial of the case. And indeed,
Is the timelines you all have to work with? I mean, is it something that you will be able to meet? And in terms of your case, you are the ones who have got the case to court. And what does it mean for putting together a solid case to put across your points?
Now, let no one say we are not prepared. If we're not prepared, we wouldn't have come to court, we wouldn't have filed the petition. To admit facts has not been dealt with. Our interrogatories, our application for review of interrogatories has been pushed to a date after the trial has started. I mean, it doesn't really make sense to us. Unfortunately, we have to say this.
Given your experience at the bar and with the experience of...
There's 5 days for pre-trial. Today is the second day.
So what's the rush for?
So what is the rush? Today is the second day for pre-trial.
5 issues have been set down for trial.
Issues we put before the court, because that would have been the essence of case management. The parties going back and forth on the various issues they filed, and the court bringing it together so that we are all agreed on the issues. That didn't happen, so we are now going to look apologized, and I think that should end it. He's a gentleman. I don't think he'll ever be deliberately rude to the court. The court took offense. He apologized, and that ends the matter. So thank you very much.
Mr. Ene, I have a specific question. Which
one? We had indicated, in our petition that we will be calling most likely 5 witnesses.
Yeah.
Okay? Now, we thought that at case management, at the time of case management, which is 5 days of on how many witnesses we are going to call. So it was not the case that we are not prepared with our witnesses. It is just the case that we are met with a situation where we are being given 1 day to prepare our witnesses and then make sure that we file the one to CI 99. There are 5 days for case management. And all of a sudden, the case management is reduced to 1 day by the court arbitrarily without any consultation with the parties. All right. Then that is like our lead counsel. We spent 8 months, right, dealing with the first presidential petition. Does not mean that now everything we do must be geared towards, attaining a speedy trial at the expense of fairness. Okay, delayed is justice denied. That is true. However, the court itself has indicated that we have 42 days to complete this trial. It means that in the wisdom of the drafters of the rules, that is the rules of court committee, 42 days that are mandated and allowed by law just because we want a speedy trial. Okay, and I mean, to be honest with you, I was shocked at what was happening, and you all realize that the Chief Justice singled me out, that my body language was inappropriate. But that is because I was very deadlines. Okay, and sitting down there, it reminded me of an inscription that was on the desk of my secondary school rector in Notre Dame Secondary School. It said, "Don't confuse me with the facts. My mind is made up." Thank you.
Ordinarily, when you file your petition and the respondents file their answer, the next logical step is case management, which starts with a setting out of the issues, 2-day clock. That was granted. We had the opportunity to come back earlier this week, and the afternoon before we appeared in court, they filed another interlocutory application, which, as you all saw, took us. Second, your witness statement, you have a draft of it. So these matters become procedural. Because our colleagues are seeking to delay the process and get a media spectacle ongoing for some months, all they are doing is theatrics of proceedings. Every lawyer knows this. So you cannot claim or pretend before the cameras that by mere virtue of the fact that you have filed an application for review, there ought to be a stay of proceedings. Because it has actually been, I think, slated for hearing tomorrow.
What they are doing is due process.
They are allowed to take an exception. But I want to come to another issue. When the court determined in the end that witness statements should be filed on X or Y date, you can check from any other lawyer. Mr. Mahama filed. Today, when the court says that by this date, bring me the witness statement, now they say it's too short and that they are being rushed into putting together witness statement. We didn't choose their witnesses for them. From 30th of December till now is what, 20 or 21 days? I mean, fair idea what it takes to contend this case. Now, if they claim that they need to go back to the interrogatories before they can agree to the issues as have been set out and prepare their witness statement, what it means is that their application +1. You have an opportunity in court to prove that. Now Mr. Mahama abandons that one and moves on to this new thing of nobody got 50%. And when we say bring your witness statements, he says it's too early to bring his witness statements. Okay. That's ridiculous. And we are looking,
to benefit if they delay the process.
For a media spectacle so that Mr. Mahama can continue to remain very relevant in the NDC and in the public space and run again in 2024. That's all they are looking for.
So he stated that in terms of case management,
in fact, traditionally, the court will set out the issues. Now with the reviews, CI 87, etc., with the reviews, the court will invite counsel that give us your memorandum of issues and let us come up with a timetable. Let's listen to your issues and simplify. We went with 3 issues. And then the court came memorandum of issues. After they submitted their petition on the 30th of December, now they are being asked to bring their witness statements. They are suggesting that it's too early. 21 days after they told the whole world that these are our witnesses, they have evidence to support our petition. And that is why we are saying...
Ruling was today. How would you summarize it today?
The court has ruled today that let us get on with the issues. Let the petitioner prove that nobody got 50% +1. Let the petitioner prove that the results were in contrast us to come and deal with the issues that it has set. In Chi, court.
All right, thank you very much. And that was the Minister for Information, Mr. Kojo Ponkroma, speaking to us earlier. We also spoke with the Minister, well, the President's representative at the Ministry of Information, making a claim, a very strong claim, and I'll be joined by my colleague Edward Nyakon, Barbara, who also joined me at the moment. So as we begin to wrap up for